When people get older or suffer from mental disabilities like Alzheimer's disease, they can do things that they don't mean to do, like signing over all of their assets and real estate to their friends and cutting out their entire family in the process. Well, believe it or not, these type of situations do happen all the time, not just in the movies. This is the exact scenario Dave and his family were in. Dave and his cousins were the only family that their Uncle Mike had. Mike was never married. Mike never had any of his own children. His nieces and his nephews were his family. Mike had told his family over the years, as he got older, that he would provide for them when he died through his estate. And his estate planning documents, his will and his trust, were drafted to do just that. He was leaving everything to his family upon his death through his will and trust. I'm Scott Richmond, and I'm an Illinois litigation attorney with Ariano Hardy Writ. And since 1981, our firm has been helping Chicagoland residents with their legal problems. Unfortunately, Mike developed Alzheimer's disease, and as it progressed and as he aged, eventually he was no longer capable of caring for himself and needed full-time care. Mike was no longer competent to make decisions on his own, and he couldn't live by himself. It was at that time that Dave and the family found out that despite his medical issues, with his mental capabilities, Uncle Mike signed a new will and trust to cut out his entire family and name his friends as the sole heirs. The problem with this is that Mike changed his estate planning documents when he was no longer competent and was influenced by his friends who benefited from his new will and trust. According to the law in the state of Illinois, you must be competent and capable of understanding your financial decisions and knowing the extent of your property when completing estate planning documents, like a will and a trust in this case. In this case, that was not true. Mike was not mentally capable of understanding what he was doing when his new will and trust were signed and was the victim of undue influence by others. This means that the documents were challengeable in court by the family, and this is exactly what Dave did. We were hired to challenge the validity of the later signed will and trust by arguing that Uncle Mike was not competent at the time he signed them and that they should be disregarded by the court. At the end of the day, it was found that Mike was not competent at the time he executed his last will and trust, and that will and trust was therefore invalid. This meant that the family would receive the assets upon Mike's death that he had intended for them to have and had promised his family to take care of them. If you find yourself in a similar position or interested in receiving more information about estate planning or estate litigation, schedule a time to meet with our team to review your case and get all of your options. We regularly handle estate planning and estate litigation matters and can assist you.